Day after tomorrow. It can be listed tomorrow also if you want.
Yes, my lord, tomorrow.
Tomorrow,
Apply.
content.
That is wrong. The listing of the one inspection ballot, ordering was complaint on that. Listener paid for as well. Because we are two of listed, non-mallet is receiving.
For admission.
Mallet Friday kindly.
Admission or hearing? Admission.
Friday kindly.
Friday. All right, if you will have it on Friday, let us.
Apply.
Yes.
The matter was final 24th of last month. The matter had come up on 31st, but then all the court did not say it. It means the matter. The proof was issued your lordship in purported violation of the governing directive. That is slightly urgent in that regard.
All right, let us have it on 16th.
Lordship 12th is the last day on which the like. In fact, this is the second one.
You are making a mention today.
In fact, the matter had come up here on 31st.
Thereafter you did not make a mention.
I did not make a mention to set the matter to come up in daily course. My great my lordship acknowledging the 15 budget. And the great of my daily.
You try on Friday, we'll see. We don't know. Friday.
I'll be grateful.
Thank you very much. I think 5 months. May I take a job with my phone?
When?
In fact, I'll check that because a lot of people we have to take questions. The file is operating. The policy, can you have to finish. In the meantime, we complete first.
Item 5. That's not taken.
No, we have to take it after that. 1, 3, and 4. In this background, I'm doing the journey for 4 weeks.
You have to take steps. Fresh steps. Mr. S. Onik Leonard, counsel for the petitioner, is permitted 2 weeks further time to take fresh steps on respondents 1, 3, and 4.
And that will be listed after 3 weeks or 4 weeks.
Might be listed after 3 weeks.
Yeah, I wish to mention for listing, individual means pending since 19, because last March 2020.
For admission hearing.
For hearing my lord.
For hearing.
My lord, pleadings is completed, matters regarding my lord are included, my lord. Hearing my lord. It will dispose of my lord.
Which matter? Which year?
2019.
19 matter.
17, it's a hearing day, my lord.
No, every day is a hearing day. Problem with that.
My lord.
We can have it on 22nd.
Second. Obliged, ma'am.
Yes.
Item 11 from Parapan, they are not finding the last.
Item 11. You wait till the matter is called up. Wait till the matter is called up. Yes.
I am saying for this and my lord. 41.
Huh?
41. Based on unreviewed.
You want this to list a matter. What matter is it? Fresh matter?
Selection and appointment on
Anganwadi. So it can be on 14. List it on 21st. 21st.
I think more of these days. Not in the hard senior ones to make some submissions. So, and if the account is for today.
Mr. Dotto is there? He wants to make some submissions. You give us a date. 17th is not possible.
16, 17, I'll be out of state.
The problem is once you take an adjournment, it's very difficult to put it into a calendar within 2 weeks. The dates are all filled, the matters are fixed. We'll take it up at the end of the list if he wants.
As per your notification, otherwise, my lord, what will happen? We'll have to heart the matter. If it is delayed, then again we shall have to restart the matter.
22nd, let us see. 22nd,
Well,
at the request of Mr. Sharma and the Sharma Learned Council for the petitioner, who submits the matter we adjourn for some time enabling him to allow the arguing council to reply. List on 22nd, Mr. Hester to City Council Assistant and Mrs. Uzari appears for the respondents.
May. Consider document for listing of the case.
What matter, what stage?
Because if matter relating to regulation of my child.
You want it for admission? For admission,
Okay, sir.
for admission. On the 28th of August.
Sure. Thank you. For withdrawal supplementary list, item 18.
Yes, Mr. NZ Chaudhary,
Yeah, Mr. Yeah.
Learned Council appearing for the petitioner submits on instructions that the petitioner does not wish to press the petition any further. Accordingly, the petition stands dismissed as withdrawn. Interim order, if any, stands vacated, stand vacated. Mr. N. Pai for the respondents. Irrigation.
For motion item 19.
He has joined. He has joined. He was transferred from
Promotion from
Nagaon,
Morigaon to
Morigaon to Kamrup East. He has joined.
earlier he was the land officer, now.
Now he has joined.
He joined.
Have you seen him?
Good day, he will join.
Huh?
He will join. He in fact, he said he was invited. Good day, he will join.
He joined yesterday.
Yesterday, presenting, therefore.
So we close this petition. Heartland Council for the parties. This petition was filed by the petitioner. Aggrieved by the fact that on his promotion from the office or on his promotion as the Assistant Conservator of Forest, he was posted in the office of Divisional Forest Officer, Kamrup East Division, Bokislo, by the notification dated 26/07/2023. So petitioner handed over charge in his earlier place of posting on 27/6/2023 and proceeded to take charge in his new place of posting. Stop. However, he was not permitted to join in the new place of posting, and no reasons therefore were cited by the department. Aggrieved, he has approached this court, praying for appropriate orders. Stop. On 4/8/2023, learned Standing Council for the Forest Department was permitted to obtain instructions as to the reasons why the petitioner was not permitted to join in his new place of posting. Stop. Matter was fixed today. Stop today when the matter is called up. Mr. Gugoi, learned Council appearing for the Forest Department, has produced a copy of the joining report dated 7/8/2023. Of the joining report of the petitioner dated 7/8/2023, whereby it is stated that the petitioner is joined in the office of Divisional Forest Officer, Kanpur East Division, Okisto, Guwahati, as Assistant Conservator of Forest on promotion on 7/8/2023, forenoon. Stop. That being the case, no further cause survives in the writ petition. Stop. Both councils have agreed that the writ petition can be closed in view of the joining report. So accordingly, the writ petition stands dismissed as not pressed. The copy of the joining report dated 7/8/2023, produced by the Learned Standing Council, is kept in the case report. Writ petition is disposed of in terms of the
On the
disposed on. We don't.
The release for admission, item 1.
Yes,
May. My lord, by the last one of community. We want to pattern the directed to the report. The order is 13/6/2019.
yeah. Records available.
My lord, so much committee are concerned. They are concerned.
So far, pleadings. Yes,
Now, my lord, in this particular case, I have challenged the validity of the order dated 17/6/2019.
Hmm.
Issued by the commandant, therefore, in the compliant manner. Dismissing the petitioner from the service. The dictate from 17/6/2019. As well as the order dated 18/11/2019, passed by the deputy inspector general. Rejecting the appeal, is the high petition matter. In this particular case, the petitioner was appointed to the court of constable. General duty on 22/7/2016. He obtained the leave during his service time. He obtained the leave from 22/7/2006. And 10/1/2019 to 9/2/2001. For medical treatment of his mother, who was suffering at a living time from liver cancer. He made my lord particularly did not join the duty, and accordingly the various proposed notices were issued. But it is not issued because he was not at a home. He was within the treatment of his mother. That was the reason he did that. Subsequently, he gave the representation. But even though the order has been passed, you know, the order will be at page 26.
yes,
May I read it, my lord?
yes,
Whereas number circumstance. Virat, son of certain measures, circumstances is overtaking after expiring definitely. It depends on 10 to 19 without prior permission of the court. And there is communication directing you engineer to government. Circumstances subsequently reminded as circumstances, but it says to make it. And where is the point of inquiry of order? By order on the circumstance, after expired 30 days without it, as to standing under section 17 of.
then let us go to the show cause first.
But yes, my lord, your lordship, this so-called, I have no sign, copy of the so-called file. But they have a link with their
Affidavit,
evidence.
Page 27 now. And let us page from
Many, my lord, your lordship will be.
it is 84. From the rate page.
27.
Yes.
27 is 89 here. Anyway, we got it. Yes,
27, my lord. So,
yes,
may I read it?
yes, please.
Here is number circumstance. Circle sir, is already changed after expand the symptom give the features of circle without time or return to the sector. And where the communication directly is the secret. As your own agent, like government discussion to certain and subsequent minded to certain time, but in case the and there is a phone to be divided by rule. Okay, but in certain time, after expanding 39 your sales without as per police container and section 24 of it. And there is a newspaper COID. We understand after giving satisfied to the opinion of COI that is opposed to the justifying the arguments that are faced and is maintaining a point in your position for the report. But that was not surprise to me. I just and there is a the role by the two to the culture police society to obtain you rights certain time and it demanded that certain certain and there is here neither you have son that you said either you can or you were apprehended by the concerned you were declared as sister by Rosal and the Sapusa as the police and then Sapusa for your declaring you as you just how the meeting out with the direction after certain time about getting that is the proposal. This notice was issued by no doubt. I know this but at the given time, I was not at the court and accordingly it was not justified. Because I was busy in the treatment of my mother. Those times I have expected in life, represented in life. Now my mother is learning to the whole life.
No, what is your reply? Did you say finally reply? No.
No, because I was not at, and it was no issued by. Because I was busy between Bombay.
Let us see your application for seeking leave.
Speaking is there and it's that no to be speak. And page 19. There. That is the new certificate. That is the new certificate.
Where is it?
At page 19. Of their application.
Of their affidavit.
Yeah. Because I submitted you on that particular one, on my application, they issued the new certificate. But my application evidently.
Page 90.
Yeah,
90.
one line.
19.
They are not application that I took to you for the business of my. That expect we have. But the application which I find is in the report. That is regarding the inspection. And good my.
No, was it on the basis of some application or verbal?
Yes, definitely it was on the district of application. I find the application. For the treatment of others who are suffering at a given time from liver cancer, that application must be in the report. And on the basis of that application, this certificate was issued. But that position was not disputed. That actually be for the treatment of my mother was something at a different time. So Never came.
Is the application available?
Overstayed we got. We are not disputing, we overstayed.
Great. We want to see his application if it is there. Give a next. Page number.
I edited. Number, 19. Of my.
No, 19 is the certificate. The certificate must have been issued on the basis of some application. So that application, if it is available. Are the proceedings of court of inquiry available in the pleadings? Court of inquiry proceedings, are they available?
No, it was not supplied to me. They have also not annexed with the evidence.
So nothing was supplied to you?
No.
Only the order.
Only,
Where was the order served on you?
it was minus at email
Huh?
up on, it was issued by me. After 17/6/2009,
Page number
page number 26,
of the writ petition.
I mean, the email. Of the
26.
day.
Yes.
They have cleaned the details in this annex, which I was. But it was not supplied to me. Yes. It was the second week of July 2009. I sometime. And after constitution support of the I was not served any kind of by support of the right. Inquiring my content. And whatever the proceeding was conducted by the court of the right. That was conducted.
So your mother was discharged from the hospital on 17/2.
On many occasions, she was starting from me and after.
No, no.
But she was serious. and-
When did you get her back to your home?
My lord, I have stated each and everything in writing.
No, we are just asking for the
Yes,
dates.
yes, my lord, from time to time, I took at my home. I
See,
took her to.
your ground is that you were on leave for X period to Y period. But during that period, you went for treatment of your mother
Mother to Bombay,
to Bombay,
to.
some other place.
And sometimes we.
so On 17/6, when the order of discharge was passed, dismissal, you received it on which date?
Or in the middle of the July,
Middle of July.
second week. That
Middle
is
of
basically statement, my lord, I have made.
So after treatment of your father or mother.
Yes.
When did you return back? Because you received this while you were in your house.
My lord, subsequently, I submitted the representation, my lord. That your motive to one day come. They said 12/7/2036, I have accepted in the. Page, my lord, 36. 36.
36.
This I tried to give it to the department, my lord, 12/7/2019. But they did not accept it.
But your mother was, when was your mother discharged from the hospital?
Mother,
Mother,
was, exactly, my lord, that this is still like that was sick, but she died.
maybe
Subsequently on 1/4/2020.
discharged on 2/2/2019.
19, on many occasions, she was discharged, again she was admitted. Again, she was admitted to the hospital. Again, she was discharged, she was taken to Bombay, Banaras, many other cancer hospitals. That details I have detailed.
No, see, you belong to a discipline force. So whatever the rules and regulations you'll have to follow. So you have been given your earned leave.
Yes.
You went on earned leave, you overstayed your leave.
That is the-
Now you have to explain that on a date when the notices were sent to you,
I
you
was
did not,
at his home. That was
that's exactly what I'm asking you.
because
If you're not at home, you have to give us at least the tentative dates when you are out of home, because the discharge certificate which you have enclosed
Yeah.
to the petition annexure C, it shows the date of discharge is 2/2/2019.
that is.
And the termination dismissal order is of 17/6.
That may I just one thing can get video so that I will show the person. Everybody will get it.
If you're not ready, then you should make this prayer after opening and studying the file. Why make an adjournment, pray for an adjournment like this?
Only for 50.
That is not the only notices. We have sent him many notices.
You mark from the record,
Yes, returning notices are here, but his application, maybe it's a verbal one, because leave certificate is there, but his application is not, then neither in file I have not, but leave
you
certificate.
find out and we want to see the court of inquiry report.
Yes, these are here, Lord. He was he, before passing the order also, we have even given paper publication also.
Yes. Then we admit and it goes for hearing.
I know that neither would be near that like I want. So
This
that's
on 29th August,
that, but
at the request of Mr. O.P. Bhatti, learned counsel for the petition. Submits that he needs some time to complete his instructions. In respect of some documents which you'd like to rely to this court. MSB Sharma appears for the respondent. List on 29th.
Item number 2.
Yes,
Your lordship, this is a writ petition by the petitioner where without giving any due chance or without following any due procedure of law, he has directly been removed from the service. The dismissal order at the is at page
are pleadings completed?
27.
Pleadings are completed.
I'm not aware because we are newly engaged in this matter.
Then, do you want to file a reply or anything?
No, your lordship, they have filed an affidavit in opposition and that is sufficient.
All right.
So your lordship may just see the dismissal order at page 27. And at page 29, the last para A, it says, as such, by the virtue of powers attributed to the undersigned by the President of India through RPF Rule 161, Sub-Rule 2 of RPF Rules 1987, I hereby impose the penalty of dismissal from service with immediate effect on Constable Ashok Kumar Rao, LNG, which means Lamdi.
Was there any criminal
There is a criminal matter.
was it,
pending.
were you convicted?
No, not yet convicted. But the main thing is that your lordship, when this proceedings was going on, when this dismissal order came, I was not given at all a chance of being heard. And after the dismissal order, the necessary application was being made to the appellate authority and also to the revisional authority.
What do the respondents say in their affidavit?
The respondents here in this petition states nothing except what they have stated in their rejection application, rejection order, that has only been stated and quoted here.
You are found to be absent during the period of suspension. You are found to be absent during the
No,
period
your
of
lordship,
suspension.
during the time of suspension, they were not even allowed me to join or to work.
How can they allow you under suspension? But their statement is that you were directed to give attendance every day. But you did not do, and your mobile was switched off, your quarter was found to be locked. You were not
Your
able.
lordship, during that time, I was being arrested in the criminal matter.
Look, where have you stated that? Yes, who's appearing for the, who's appearing for the respondents? Who's appearing for the respondents? For time being, we're passing it over for the time being.
Yes.
If you want to make a mention, please make a mention before the other side begins the arguments. Why did you wait until the arguments are complete? We are passing it over for time being. Yes.
Item number 3. Why all matters after some time? What is the matter?
Challenge the appointment of private respondent.
You challenge the appointment. Why you challenge? Appointment or promotion?
Promotion.
Huh?
Promotion.
Commissioner, upon the existing officer, take a enough direction, madam.
Their biddings are complete. And what's the speaks is matter for finally scope. It's a case for election and appointment of the post of administrative officer in the office of the deputy commissioner function. To be fine. The advertisement,
No, what is this, what is the status? He is still working.
no. Her certain selection and appointment of the spotting to the post of administrative officer. Violating the rules, providing or listed service to deputy commissioner establishment service to. That is why you have stated three selection and appointment. Fact of the case is also, will find the advertisement at page 24. Of the requisition. Lordship originally a other matter and.
No, you see, for final hearing, we'll have to give preference to the older matters.
But in this particular case, my information will traditionally have already going to return in 3 months. That is why 3 months is the servicing of the for 3 months. So he repair on service. Delay will become incoming fast.
Then we'll have it on some other day. Let us fix it on 24th. 24th.
Readings are completed.
We'll take it up on 24th of August. 24th August.
For final list, Lordship record.
We'll try. If you look into the part 2 list, you will find matters from 2014 on.
Lordship, I understand. Only thing is-
So we have to give time to those.
I understand. The only thing is Lordship, traditionally it's going to return of receiving not get benefit. And the respondent has Lordship long service.
I'll put the record.
The record is not here.
I'll produce it and not on 24.
You have to tell us what is there in the record. Why do you want to give us the pleasure of going through your,
Actually, the record is clear. For the last occasion, I had missed the code.
what is clear?
Cases
As
are
per the
almost.
ACR grading, the respondent number 5 is more qualified than the petitioner.
Hmm.
Moreover, the rules are specific. The rules have to be cannot be read in isolation. The rules have to be read co-joint.
All right, you keep the records ready on 24th,
Yes, sir. Right.
24th August.
My submission will be what he is getting. Lordship. Cases regarding Lordship will be 1 point case will be allowed.
We'll hear it on 24th August.
All right.
Supplementary list for admission item 20.
It is never a senior person, KK Monto living. Not kindly part of the kindly, because he has phone number there for attending to one.
I love the reviews, but I'm not record the phone from mother. We asked for a send the record is mother, she might have on a different part. So Lordship, I'm made submit before the Lordship, Lordship, the director is still business part to submit the record. You will submit the record.
Why records were called for? For what purpose?
This is for the procedure we adopted.
What is the matter about?
Meta is regarding to the appointment of supervisor in physical handicap. It is not claiming that he is physically handicapped and OBC candidate. But we have found here the ability to file. The C got only 17 marks into retention. That's why she was below the cut-off mark. She was not for the Viva board. So she was not selected. They are seeing only 3% is only 3%. 0.5 is to be round up. And we will say the round we cannot round up on the thing. That's why the report is there. When I will see how much was given. Even now,
Did you appoint any other person with,
yes, we have appointed him. He said that was to me.
no, for this selection?
Yes. My ED selection, it is no one. When she was not qualified.
I know she was not qualified, that is why she is here. Was anybody else appointed in her place? Any other person with
No,
disability?
no, it is, yes, no. She is the only thing.
Selection pertaining to which year?
And what is it, 14%?
Then when did the person appear? When was the person appointed?
16.
Who is for the private respondent?
There is no.
Then You're asking for,
The petitioner appeared as a handicap person. No selection was made to belongs to the handicap. That is why Files of 1995 atrocity is awarded about the act.
you want to say that there is no reservation made for
Yes.
person with disability?
He is to be qualified, but reservation is there. But he to be
Petitioner
qualified.
report was confirmed.
Suppose one reservation is there, see, 1 months, whether he will be eligible.
What do you say in your affidavit?
Affidavit, three affidavit we have 5 months.
3 affidavits.
Three affidavits I have found here. Today, I am dealing with matter, Mother. I have not gone through all these things, Mother. I will take some time, Mother. Otherwise. Phone number 2, 5 affidavit, and one is developer, there is that. For the demand, motive, director, now there is really good. Three affidavits, fine. Now this. Appointment is defined thing, a social welfare development in bifurcated. One is child and women development, another is social welfare.
No, in 2016, what was this position?
Social welfare, yes, then social welfare.
Hmm.
Under social welfare, one time. So let me have one of the sport product records also. Next week, what is my director?
Why records are necessary? Why are records necessary? Because the affidavits are available here.
Yes, the statement is there, its comparative statement is there, so to compare with their, we have made it still comparative statement. So report was for,
Page.
no, we have not.
Then
We will get it
where have you received this from?
from the department.
Where have they received it from?
Director.
Where has the director received it from? If the records are under vigilance,
No, before that, one of that paper.
before that,
Thereafter, it was seized by the citizen.
so somebody managed to take out a copy of the comparative statement before the records were seized.
It is before that one.
Before that.
So, ultimate director actually cannot be required to report, otherwise not, I will it better next week, I will go towards you.
Why next week?
I have not put through all the things.
Let us hear it on Thursday.
Thursday, you have to go.
Day after tomorrow. The request of Mr. T. Sutia matter stands deferred to Thursday, enabling him to go through the enabling him to prepare the case and address the court. Mr. Monto, your counterpart wants it on Thursday.
This Thursday will not be possible.
Then it goes. Your case is that the selection for the post was not done. The reservation was not done.
Position. Yeah, admitted position.
Now, under, for how many vacancies were there? 20.
20,
So what is the 3%?
1, 0.5, 0.6, yeah.
0.6.
So one post will go.
So that is as per any rules.
Yes, under the as per rules 50%, but whether it can be rounded up to 1.
So-
that is the Supreme Court has-
So therefore, out of these 20 vacancies, assuming one post is to be reserved, then the last person who is appointed, assuming the writ petition is allowed, that person will lose the job.
Yes.
So is that person a party here without
No,
hearing?
You don't know who were appointed, because I came here
Hmm.
before the appointment was made. Right? I came here before the
No,
appointment.
then you'll have to, if you do not know, then you'll have to file. Put them to notice by way of advertisement or something like that. How will they know?
They should first disclose.
Who are appointed, Mr. Sutia? List of appointees?
This was appointed. Because what happened, my lord, even they have not been able to show the selection list, numbers who have secured how much marks.
According to them, all the records are under the custody of vigilance.
Yeah, they were asked to take relevant copies by producing the order of this honorable.
Hmm.
And they said that we have done it. What is that? They are not coming with every time, my lord, I am sorry to say. Every time watching her see this case was in 16, it is 23 now. 23, every time someone comes and says that, well, we are not.
So therefore, we'll take it up on Thursday, you,
Honestly, my lord, I am having difficulty
oh,
because I will be busy in the other court, next court, I will. So I will be busy there.
when do you want it?
Next week, immediately, yeah.
Next week, there are some holidays.
Yes. Or on Friday, or
Friday. Friday, we can fix it, but we do not know if time will permit the matter.
in that case, my lord, let us, if it's a date where it will be possible, not to vote.
Let us keep it for Friday then. Let us try. Friday,
Friday. Oh, but I will be.
Friday. At joint request, and at the request of Mr. Sushil. Matter says adjourned till Friday, Mr. A.K. Montal and the senior council. Does not object to the prayer meeting. List again on Friday. Let us make an attempt. to see.
Yes,
Item number 6.
What you make it matter, service, complaints or no epidemic. So we will come time to file it. I am preparing for 2 and 3. And that may be.
Why was it listed? Why is it listed today? Should not have been listed today.
Order.
You are appearing for whom?
2 and 3.
Who are 2 and 3?
The whole referendum.
And you are to take steps on whom?
So silence, I think it is complaint. Not that I know my operator. Logima order is also there. So it can get things time to file it.
Who is 4, 5 and 6?
Worship, they are employees of NRL.
Hmm.
They are the Monica refinery. They are officers.
Anyone appearing for 4, 5 and 6? They filed wakalat now. Somebody has filed wakalat now.
But service has been copied.
Yes, they are represented by council. Yes, Mr. M. Gugoi, learned counsel, according for respondent 2 and 3. Submits that he would like to complete his instructions and file necessary counter affidavit in the matter. He prays for 3 weeks. 3 weeks time. Mr.
P board letter.
P. Border Learned Council to the petitioner submits that service is complete. The matter be listed after 3 weeks
For admission.
for admission. List accordingly.
Can I definitely pick it?
Let the affidavit come. There are.
Obliged.
Item number 7.
In this case, the application and owner of the same violation to country. It's not one of those why the civil mechanism has been beat up because there is a direction from the Honorable Court. Which was passed on 19/2023 in expedition number 251 of the 2023. Because there is only one court in which project the petitioner is has to be considered in terms of the order of the submission.
Just now, I have a document, may I share it?
Where is the order dated? 1905?
95 will start from December 88.
88.
Yes. And order is very much specific, nothing. So, honorable court has clarified that, and that there is a vacancy. As the respondent authority has already submitted their affidavit in opposition, whereby the respondent authority has also clarified that there is a single vacant post.
Worship, may I, the order, how many part of the order?
Let us have it. Which order?
Page number 90, the operative part of the order.
Yes, yes.
It's almost the last paragraph, middle of the page. In view of the above, this petition has been disposed of with the direction upon the respondent number 4, 5, and 6 to examine the claim of the petitioner for promotion to the post of LDA, and on such examination, if it is found that the petitioner is entitled for consideration for promotion as per the provisions of rules of 93, and that there is a vacant post of LDA in the establishment of respondent number 6, then in the event the appropriate steps will be taken for consideration of the case of the petitioner for promotion to the post of LDA along with other eligible departmental candidates by duly constituted selection committee.
And where is the impugned order?
Imperial order is case number 93.
93.
And after on 22 May 2023, the respondent authority has in contrary to the provision laid down under the under rule 13 logic. He has been the private respondent has been appointed in violating to the on direction of the honorable court. Wherein the honorable court clarified that there is a vacancy because it has come from the affidavit that has been filed by the respondent.
So why is this order at 93 violative of the order, of the court's order?
The respondent authority has violated because
No. Why are you saying it is violative?
because Lordship, the respondent authority, who is the appointing authority, he has filed an affidavit before this honorable court that the respondent number 5, and he has been represented by the council of the before this honorable court. And so far the other respondent party is concerned, Lordship, they have clarified before this honorable court that that your Lordship will find it case number 71, Lordship.
Yes.
Here it, Lordship. There are 4.
One minute.
The son of the respondent number 4 in the that information is that Lordship, you will
What is the meaning of this last paragraph, last line? Moreover,
Last paragraph, more. Subsequently, the vacancy will.
end of the line, end of the paragraph.
For one whole entire, Lordship, there's this earlier previous thing is there. That there's only one post, your Lordship. Or there, that is what they're trying to mean, your Lordship.
No, they say there is no vacant post, no sanction post.
There's no section. This one, yeah. In the first paragraph, last line it is here. Here it is to be mentioned that there is one post, one number of LDA posts under Lakhimpur district treasury establishment.
Hmm.
So entire district treasury establishment, there is one post, your Lordship. But that is what they are saying, that in this sub treasury, there is no vacant post. That's what they are trying to say, your Lordship.
Where is that one post available?
That I want to mention.
That
It is not clear from here also. I think where this private respondent is right now. That would be the.
Where is the private respondent?
File at page number 70, start from page number 73. This is the affidavit filed by the respondent number 4.
No, first let us come to 93. 93.
Yes,
You say this order is violative of the court's order.
yes, sir.
Why?
Lordship, as the respondent number 4 has filed their affidavit before the honorable court that there is only one, there is a single vacant post, and that single vacant post will be filled up by way of direct recruitment. And the after the that affidavit has been already paid off at the time of hearing. Lordship. And the honorable court will come to the conclusion that no, though there is 80 and 20%, 80% would be direct recruitment and 20% would be Lordship promotion. But in this case, Lordship, for that single post, the case of the petitioner should be considered for promotion along with the other candidate, not to be filled up by way of direct recruitment. Only on the basis of the affidavit filed by the respondent number 4 and 5. Lordship. If that is a matter of record, Lordship, I have enclosed here. And your honorable court was, has also discussed the affidavit filed by the respondent number 4.
What was the direction of the court?
Examine the page number 90. Your Lordship.
Lordship.
Yes.
In view of the above, this writ petition is being disposed of with the direction upon the respondent number 4, 5, and 6 to examine the claim of the petitioner for promotion to the post of LDA. And on such examination, if it is found that the petitioner is entitled to be considered for promotion as per the provision of the rules of 1993, and that there is a vacant post, because your honorable court has indicated that the respondent number 4 has already informed before this honorable court that there is a single vacant post. That there is a vacant post of LDA in the establishment of the respondent number 6. Then in that event, appropriate step be taken for consideration of the case of the petitioner for promotion to the post of LDA.
They have replied that there is no vacant post under sub treasury.
There is two conditions. Either they mislead the honorable court and the on the basis of the affidavit, misleading affidavit.
Where is the respondent number 7 presently posted? Private respondent.
Lordship, though the Lordship, the petitioner has been working under the respondent number 6.
No, not 6. Somebody is promoted.
Yes, not promoted.
Then?
Not promoted. Lordship. This is the only single vacant post, and for the person who has been promoted, Lordship,
board-
that single vacant post has been promoted. Lordship, in the last-
Court's order is to examine and give you consider your case if there is a vacant post under respondent 6, which is the sub treasury.
No, that is on the basis of the affidavit filed by the respondent number 4. Your Lordship will find at page number, the respondent number 4 has filed the affidavit on behalf of respondent number 4, 5, and 6.
Page number?
Page number 73. Your Lordship will find. Para 4, Lordship. 73 is appointed person of the affidavit.
Yes.
May I read, Lordship?
Yes.
Then with regard to the statement made in paragraph 7, 10, and 11 of the writ petition, the deponent stated that as per rule 5.3 of the Assam Treasury Establishment Service Rule 1993, promotion of grade 4 to the cadre of lower division assistant is to be made by direct recruitment and by promotion in the ratio of 80:20. As per our office record, it seems that already 3 numbers of grade 4 employee of this treasury establishment have already been promoted to the next higher cadre of lower division assistant since 1997 as follows. And the person who has been promoted, they are the junior to the Lordship petitioner.
Do you dispute the ratio 80-20?
Lordship, that ratio has been carried by the Congress. I have disputed. Lordship. I will
Yes.
come to the next part. Lordship.
Ah,
I will come to it. Page number 75. From the above, it reveals that promotional quota of lower division assistant of this treasury establishment have already filled up. The one number of vacant post of lower division assistant is kept reserved for direct recruitment. Hence, the case of Kushal Hazarika, grade 4, Ropahana Sampradaya could not be considered for promotion. His case will be considered after fulfillment of direct recruitment quota 80% of the federation. Now the honorable court will have come to the conclusion that nothing, if there is a single vacant post, that single vacancy post should not be filled up by way of direct recruitment, because for the 30 years the petitioner has been discharging the duties as a duties of grade 3 and grade 4 post. So he has been appointed as a grade 4 employee. And your honorable court has also discussed this part also. The petitioner has been discharging the duties of LDA.
so there is no dispute that there are 4 posts. Out of that, 3 has been filled up by way of promotion.
If there is 4 posts, there is only a single vacant post, single post. In that single post, in the earlier occasion, 3 person has been promoted. Now,
He gets 1 post.
yes,
There is only one post.
one post. So now the honorable court has come to the conclusion that no, this time you should have considered the case of the petitioner for promotion, not by direct recruitment. This is the case.
No, I don't think that is the mandate.
This is-
Kindly read page 89 last paragraph.
But so far the affidavit part is.
No, you read the order of the court because you are basing your case on the order of the court.
That we would be significant
No.
to note
Ah.
hearing that.
Ah.
And hearing is that as per provision of rule 53 of the rules 1993, only 20% of the post of LDA out of the total cadre can be filled up by way of promotion, and therefore, as submitted by the learned government advocate, if the total number of posts of LDA is 4, then it is not understood as to how as many as 3 persons could have been promoted to the post of LDA. The said aspect of the matter is not clear from the pleading available on record. It is also not clear as to whether only 3 candidates to the post of LDA presently serving under the respondent number 6 are promoted, and or any of them is a direct recruitment. Now, so far my humble understanding.
No,
is
then read,
concerned,
then read.
There may be a,
No, then continue reading.
Yes,
Next
sir.
paragraph.
Since law is firmly settled that right to be considered for promotion is a fundamental right, and considering the fact that the petitioner has rendered more than 3 decades of service without any promotional avenue, and also in view of the fact that he is due for retirement in the month of December 2023. This court is of the opinion that instead of keeping this petition pending any further, a direction should be issued to the authorities to examine the claim of the petitioner in the light of the provision of Rule 1993 and take appropriate action in the matter as may be permissible under the law. And remaining parts of it I have already done. But it is very much clear. There is only, if there is 4 posts, there are 3 posts has been filled up by way of promotion, 1 post is vacant. In that post also, my case has to be considered.
Yeah, how many posts are
No,
there?
there is only one post. I also had a talk with the treasury officer. There's only one post. 80-20 means that 80% from direct recruitment and 20% from promotion. It means that 1 person is there from direct recruitment. Second is there for direct recruitment. Then on the 5th occasion, the promoting will be there.
Who will keep a record of that?
That is what the affidavit also says.
No, your affidavit can say anything. But what does the rule say? Where are the rules?
As far as the rule is concerned, yes, annex one, annex one is annex your lordship.
Yes.
Page number 102, 5. Rule 53.
102.
Yes, sir. So, but the order of this honorable court is that there is only one post is vacant. Either there is 4 posts or a single vacant, single. Post.
Page number 102, lordship, rule 5, sub rule 3. Recruitment to the cadre of the lower division assistant shall be made A by direct recruitment and B by promotion against 20% of the cadre of the 20% of the strength of the cadre in accordance with rule 11 and 12.
What is your cadre strength?
As far as LD is concerned, only 1 year lordship.
How can it be?
Let me get the instruction. Otherwise, the letter is also indicating the same thing, that there's only one. And so,
No, letter may indicate anything.
no, I also called the treasurer officer. She was also saying that there's only one post for this treasury, for of LDA for the entire treasury establishment for this district.
Kindly come to page 89. This is the finding of the court. Page 89, penultimate paragraph.
What would be significant in that paragraph? What would be significant note here is that as per provision of rule 53 of the rules of 93, only 20% of the posts of LDA out of the total cadre strength can be filled up by way of promotion, and therefore as submitted by the London government advocate, if the total number of posts is 4, if the total number of posts is 4, then it is not understood as to how as many as 3% could have been promoted to the post of LDA.
So this is what you are required to do. If there is one post, then how do you fill it up on the basis of these rules? There has to be a clear averment that there is only one post in the entire district.
In this case, I mean, that anyway, this is come for orders that will find the affidavit. Your Lordship.
But my criticism as far as concerned is going to impact and the honorable court has disposed of the petition only because of considering that he is going to return in the month of December. And if he will return in the month of December, his consent has to be submitted within September. Therefore, his consent to be considered.
We are disposing it off with a clear direction for you, for the department to examine this case again. Pass a specific order as to whether his case can be considered for promotion in terms of the earlier direction, read with the rules. And there must be a clear indication how many vacancies are available.
Lordship will kindly observe that, because otherwise it is also true, it is also.
There only my only solution is that so for the number of vacant posts is concerned. As the honorable court has already discussed that if the 3 posts has been filled up out of 4 posts, then 1 post has been one post is remain vacant for fill up. And the stand of the respondent number 4 was in the entire affidavit that post will be filled up by way of direct recruitment. And the honorable court has said that on if that there is a single vacant post as per the affidavit submitted by the respondent number 4, then in that post petitioner has to be considered for form. That is the case. Either it is not disputed whether there is a single vacant post or there is
Where is their affidavit?
let's say page number 77.
73 and 74 the operating part.
Page number 74. And 75 is what it? It's not dispute how many posts is it?
So page number 70.
Page number
4 and 75.
75 is nothing. That is operating part of the affidavit nothing.
75.
Yes, sir. May I read nothing? Here specifically the respondent number 4 has said that nothing. Case of the petitioner cannot be considered because there is single vacant.
Is not clear from 74.
The page number 75. May I read nothing?
Yes, please read.
From above, it reveals that promotion and total provided with an assessment of this treasury establishment has already filled up. The one number of vacant posts of lower division assistant is kept reserved for direct recruitment. It is specific logic. Either
Does it reveal the cadre strength?
no, my submission is not that one. My submission is
Your
that
we are not on your submission, we are on the averments made in the affidavit. From the affidavit,
Yes, sir.
is it clear that there is one post or there are 4 posts? And this is reflected in the order of the non single judge, coordinate bench. So the
they are-
first thing to find out is how many posts are there
they are-
and what is the ratio.
Lordship, only one small submission, Lordship. Either there is the total calorie stand is 4, or it may be 1. The honorable court is, as per the affidavit submitted by the respondent authority, it has been made clear that there is single vacant post to be filled up by direct recruitment.
No,
It is clear.
no, it is clear that there is one post
It's
and
laying
that,
vacant, Lordship.
huh?
Is there one number of?
Yes,
posts
it-
of-
one
Lordship,
vacant
is
post.
vacant.
One vacant post, which is to be reserved for direct recruitment
Yes, sir.
on the ground that the rule suggests 80-20.
Lordship, so far the other 74 participants are there, these are the persons they are promoted or 74, your lordship will, lordship may kindly come,
See the dates in page number 20 for the promotion order.
Hmm.
One is in 97, 29/8/97. One is on 9/12/2002. One is on 25/8/2008. One post, one person retired, the other person gets the thing. That is what is happening.
that is why lordship, if there is a single vacant post, then my case has to be considered. Before considering my case, without lordship complying with the judgment of this honorable court, they are not even waiting for that 3 months, lordship, they have directly repeated lordship instead of direction of this honorable court.
Kindly see the direction of the court, page 90.
Yes, your lordship.
Kindly read from the paragraph in view of the above.
In view of the above, this writ petition is being disposed of with a direction upon the respondent number 4, 5, and 6 to examine the claim of the. Before that, lordship, I may be allowed to.
Why don't you read the paragraph?
Before that, I may be allowed to come to the previous paragraph.
No, kindly read this paragraph first, then we can go back to your paragraph.
In view of the above, this writ petition is being disposed of with a direction upon the respondent number 4, 5, and 6 to examine the claim of the petitioner for promotion to the post of LDA. And on such examination, if it is found that the petitioner is entitled to be considered for promotion as per the provision of the rules 1993, and that there is a vacant post, that has been laid, already respondent number has submitted the evidence, that there is a vacant post of LDA in the establishment of respondent number 6, then in that event, appropriate steps be taken for consideration of the case of the petitioner for promotion to the post of LDA, along with other eligible departmental candidates, and by a duly constituted selection committee.
Now, what is the meaning of the direction? Number 1, your case is to be considered.
Yes, sir.
2, it is to be considered as per the rules.
Yes, sir.
Number 3, if there is a vacant post,
Yes, sir.
then your case will be considered with other similarly situated candidates. Now, if there is one vacant post,
Yes.
as you say,
Yes.
and only one, where is the scope to consider with other similarly situated? So therefore, the direction of the court is not just one. It contains 4 parts. You have to read all of them together.
Before that, there is a typographical mistake in this order, if I am not wrong, lordship. Your lordship may kindly come to the previous paragraph of the page number 89.
Hmm.
Your lordship will find. What would be significant to note herein is that as per provision of rule 5.3 of the rule of 1993, only 20% of the post of LDA out of total cadre strength can be picked up by way of promotion. And therefore, as submitted by the learned government advocate, if the total number of post of LDA is 4, then it is not understood as to how as many as 3 persons could have been promoted to the post of LDA. This said aspect of the matter is not clear from the pleading available on record. It is also not clear as to whether all the 3 candidates to the post of LDA presently serving under the post of respondent number 6. Lordship, here, lordship, they are not working under the respondent number 6. Because the respondent number 4 is the sole authority. He has filed the affidavit stating that there is under his establishment, there is.
You have not come for review of this order. You did not come for clarification or review.
Because this order has.
You are concerned with only one part of that order of the direction, that is vacant post.
Yes, sir.
But that vacant post order cannot be read in isolation. It contains 4 parts. Your case will have to be permitted to be considered under the rules.
So far the.
There is no clear finding of
so
the
far
court.
report-
There is no finding of the writ court. There is only one post.
But.
The finding of the report is that there is one vacant post.
Okay, finding of this honorable court is that at this present point of time, also there is a single vacancy.
Yes, we agree with that. That does not give you a right to be considered
That
beyond the rules.
And the honorable court has by passing the mandamus notice, so honorable court has directed that. if there is-
Consider as per rules.
Let me.
Consider as per rules.
Yes, in that single vacant post. also, that is
No,
what-
consider as per rules.
No, the honor.
If you are aggrieved, you can go in review or appeal against this order. You have not. The direction of the court is to consider your case as per the rules. Whether the rules permit you or not is not clear from this reply.
No, so far the 20%, previous breakup is concerned, that the honorable court has already discussed.
We have heard you. We have heard both the councils. Now allow us to pass the order. Heard, then it councils for the parties. This writ petition is filed by the petitioner. Who is serving as a peon in the office of the Dhokwa Sub Treasury, Dhokwa. Stop. Petitioner was appointed as the grade 4 employee on 12/8/1991. So since then, he has discharged his duties without any blame or blemish to the satisfaction of all concerned. Stop. The petitioner submits, the petitioner contends that time and again, he was permitted to be engaged to discharge the duties of the lower division assistant as well as the junior division assistant in the office of the sub treasury Dhokwa. Stop. The grievance of the petitioner is that the petitioner, in spite of rendering more than 31 years of service, was neither granted any additional pay for discharge of his duties as lower division assistant as well as junior accountant assistant, nor was he considered for the post of promotion, nor was he considered for promotion to the post of LDA. So, being aggrieved, he approached his court by filing WPC 211 of 2022. So, this court by order dated 19/5/2023 disposed of the writ petition with the following direction. Number 89, page number 90, extract. Kindly extract from the marked portions. The petitioner thereafter represented before the authorities concerned, requesting them to pass appropriate orders in terms of the directions issued by the board by order dated so and so passed in WPC so and so. Stop. Thereafter, since no orders were passed, in spite of repeated requests and representations, petitioners approached this court for a second time, praying for appropriate rates or the direction to the respondent authorities to promote the petitioner to the post of LDA or to a suitable post equivalent. and pass other adequate orders. Stop. The grievance of the grievance of the petitioner is that there is a categorical, that there is a specific finding by the writ court in the earlier round of litigation that there was one vacant post available, one vacant post of LDA available under the respondent number 6. And that the petitioner's case was to be considered. And if that vacant post was found to be available, the petitioner, the respondents were directed to promote the petitioner to the safe vacant post. Stop. In spite of such specific and clear direction, the respondent authorities have neglected or failed to pass consequential orders. So, the respondents have had filed their affidavits disputing the contention of the petitioner. Stop. In the affidavit filed by the whose treasury officer, respondent 6.
Respondent number 4. I did it.
I'm sorry, sir.
Respondent number 5.
In this, there is no affidavit.
No.
Please strike out the blank. Learned counsel for the respondents, appearing for the respondent, Mr. Hazarika submits that no affidavit has been filed, but he has received a copy of the order, a copy of a communication dated 05/07/2023, issued by the treasury officer to the director of accounts and treasuries, explaining the vacancy position of the in respect of the post of LDA in the office of the treasury officer, Tokuakana, sub-treasury. Stop. By the same communication, it is stated that since as per the reports, already 3 numbers of grade 4 employees of the treasury establishment have been promoted to the post of LDA on rotation basis in the year 1997, 2002, and 2008. As such, the promotional quota of LDA has been filled up and the post has been kept reserved for direct recruitment. Stop. Under such circumstances, the case of the petitioner, namely Sri so-and-so, grade 4, Tokuakana sub-treasury, could not be considered for promotion as of date. So, although learned government council has renewed his prayer for filing necessary affidavit, considering the issues involved in the matter, and more particularly that this is a second round of the writ petition filed by the petitioner claiming promotion to the vacant post of LDA, stated to be available under the office of treasury officer, Tokuakana's sub-treasury. This court is of the view that the matter requires urgent disposal, more particularly since it is submitted, the petitioner will retire in the year 23.
Yes, sir.
Stop. The learned counsels for the parties have been heard. Pleadings on record have been carefully produced. The rules which govern the services of the petitioner, as is submitted by the councils of the bar are the Assam Treasury within bracket Establishment Service Rules 1993. So as per Rule 5 within bracket 3, the method of recruitment to the cadre of to the cadre of lower division assistant shall be made in the following manner. Please extract Rule 5.3, page 102. Stop. As per Rule 6 of the same rules, there is a provision for direct recruitment to the posts of lower division assistant inter alia, and the procedure is prescribed under the state Rule 6 within bracket 1.
Full parking is the.
As per the schedule appended to the rules, Schedule 1 appended to the rules, the lower division assistant, the number of posts of lower division assistant are shown to be 25. Within bracket 2 permanent and 23 temporary. So. There are this quote by the earlier order dated so and so. Reported a finding that from the pleadings filed by the department, the number of posts available with in the department was not clear. Stop. Under such circumstances, it is also recorded that it is not clear whether all the 3 persons reflected in the pleadings were promotees or direct recruitments. Stop. What is evident from the order is that the court and bench had returned a finding that there is one clear vacancy under the office of the treasury officers of Bokhana sub-treasury. Stop. In that view of the matter, the writ petition was disposed of, directing the respondents to examine the claim of the petitioner for promotion to the post of LDA. And on such examination, if it is found that the petitioner is entitled to be considered for promotion, as per the provisions of the rules of 1983, and that there is a vacant post of LDA in the establishment of the treasury officer, then in that event, the appropriate steps were directed to be taken for consideration of the case of the petitioner for promotion to the post of LDA, along with other eligible departmental candidates by a duly constituted selection committee. Stop. We have perused this order carefully. This court has carefully perused this order, as well as the order, as well as the communication dated 5/7/2023, issued by the Treasury Officer to the Director of Accounts and Treasuries. The said communication reads as under. Please extract. Para. Upon careful perusal of the said communication, it is seen that the direction of the court was to consider the case of the petitioner as per the provisions of the rules. And thereafter, upon due examination, if it was found that the petitioner was entitled to a promotion under the rules of 1993, and that there is a vacant post of LDA, then appropriate steps were to be taken for consideration of the case of the petitioner to the post of LDA, along with other eligible departmental candidates by a duly constituted selection committee. Stop. A bare perusal of the same communication does not. Bare perusal of the same communication reveals that the manner in which the case of the petitioner was directed to be considered was certainly not considered by the departmental authorities. There is no reference in the state communication as to the cadre strength in respect of LDA available under the office of the Treasury Officer, the district, as well as to how the post within bracket S available in the cadre of LDA available under the office of the Treasury Officer are required to be filled up as per the provisions of the rules. And whether the case of the petitioner was considered in terms of the rules, and if so, whether the same was done by a duly constituted selection committee are not discernible from the contents of the communication dated so and so. Under such circumstances, this court is of the view that the writ petition, that the respondents are liable to be directed to proceed with the examination and consideration of the case of the petitioner in terms of the directions issued by this court by order dated so and so. Passed in, where is that order?
7,
It's not now, it's
88. Passed in WBC number 2111 of 22 on 1952.
Order dated 19/5/2023, passed in WPC 2/111 of 2022. Stop. The case of the petitioner will be considered by the respondent authorities, competent respondent authorities, by constituting by duly constituting selection committee, and thereupon the case of the petitioner along with other eligible candidates will be considered for promotion to any vacant posts available in the cadre of LDA in terms of the provisions of the rules of 1993. Upon such consideration, if it is found that the petitioner's case for promotion as claimed, if the petitioner is entitled to be promoted, then the consequential orders promoting the petitioner to the same post of LDA be issued by the department expeditiously. Stop. This direction is issued keeping in view the fact that the learned counsel for the petitioner submits that the petitioner is due to retire within the year of 2023, and which is not disputed by the learned government counsel. In terms of the above, the writ petition stands disposed of. The entire exercise is directed to be completed within a period of 30 days from the date of receipt of a certified copy of this order.
One point, you also said that first constitute the selection body and then. But initial examination need not be considered, need not be done.
You're not doing the initial examination in spite of direction. You are entitled to be issued a contempt notice. We are refraining from doing it. Initial examination not to have been done, it has not been done.
Highly unlikely.
Yes,
That's why I'm referring to explanation number two.
what do you say?
We have no, personal matter.
No objection. All right, Mr. So-and-so, Leonard Council appears for order number 2. All right. This goes.
I think item number 2.
Yes. Yes, what do you say?
Yes.
He was dismissed without giving any opportunity, that is his case.
Also, we said here that no charge sheet evidence because we so recourse to 161(2), which heard from holding any inquiry.
Why?
We take it without,
Why?
because the allegation is serious, it is the name in the FIR, charge sheet has been filed in the case. The girl identified the victim girl, identified the other two, but he did not attend the EIP lodging. And neither he, when he asked for attendance in the inquiry lodging, he did not attend. And the co-accused named him that he was present. On the basis of all this, we took the action.
Oh, accused is not a strong evidence.
Otherwise, he did not get corrected, that's the. But he absconded from the, he was put placed under suspension, he absconded. When he asked, I need to appear in the inquiry.
Wait, what?
A lordship that we find from the inquiry report, lordship. In our affidavit.
No, inquiry report is okay, but
And why?
the fact that did you issue it notices, how, when, why do you, when did you find him absconding? Where was he posted?
Lordship, we give a chance.
When?
For that, we will produce the record, lordship.
What is this? Produce the record. We are not interested in going through your records. We want you to address the court. We thought without the
So far as
records.
so far as the.
Going through the records is not our duty.
So that will prove that whether he notice has been served or.
That is for you to submit. That is for you to submit to say that notices have been served and it is available in the record.
That can be reflected only from the record.
So we'll examine it.
Lordship, I have to produce lordship.
You produce, but we are not examining. Unless you say that it is available in the report.
No,
But that will not preclude us to get a relief from this court, your lordship. And so far as the decision which was being laid down in the Ayush Tomar matter clearly specifies that even though 161 sub-rule 2 specifies that inquiry can be done, but they must record reasons.
Exactly.
What are the reasons? We don't know. They have done an inquiry, preliminary inquiry.
Forget about you, even the council doesn't know.
Yes, even the preliminary.
He doesn't know, he
inquiry-
doesn't have the records, so let him give an opportunity, let us give him an opportunity, let him produce the records.
Short date maybe.
Very short date, yes. When?
20th of August.
Hmm?
Or in the first week of September.
1st September,
No, that will be quite late.
when?
30.
Hmm?
30.
30. All right, 30.
Fine.
The request of Mr. B. Chakraborty, Leonard CDC, appearing for the respondents, matters stand adjourned. As he seeks some time to call for the relevant records of the inquiry proceedings. And the connected records, not just inquiry proceedings, connected records. Relating to the petitioner. Stop. He praised that the matter be listed after few weeks, 2 weeks, so enabling him to obtain and complete his report. Information, instructions. So, Learned counsel, so and so appears for the petitioner. Let the matter be listed again on 30
Yes.
August.
Okay.
Who to say is দুইটা part আছে এখানে। I think it is eight to cut. Eight is also shown as part of item 8.
For hearing item number 8.
Yes.
Was penalized by the Allah district. Where the act says, my lord, it should have accepted power under section 21. Instead of that matter, state your matter, they had found and it was penalty by discharge. The total loss is 50. Petitioner referred to the bill page 19 matter, that also rejected matter. With technical ground. So the last petition matter, climate council was for the respondent were asked to show matter. Why matter June 26 has been taken into account for imposing penalty for absent.
Where is the show cause notice?
Matter, also at page
15.
matter, it starts from the. The undergone matter for my absence. I have undergone all the penalties that have been imposed on
So this is show cause after inquiry.
Trademark everything not.
No, this page number 15 is a show cause. This is pursuant to the court of inquiry. So where is the court of inquiry?
I have trademark.
I review about 200. What is the what is the act? Which act?
Sasastra Simabal Act 2007. and-
SSB Act.
One deals with ballot absent. Rule 26, the city government not affected.
He is not served with a court of inquiry report.
No,
Logic, no. Logic may kindly, comes to section 7. Rule 26. Who have followed it, Logic? Termination of service of another person on the ground of unsuitability. Where a commanding officer not below the rank of commanded. We had issued so-called notice to him. Asking him to make a representation within 15 days. Lordship. As before that, Lordship, before discharging him from service, Lordship, his 26(2) provision is also
Now, recommendation is for punishment under 21G.
Lordship.
Now, where is the power of the
Yes, Lordship, section
disciplinary authority?
50 is the punishment.
Hmm?
So Lordship, fourth court has both the power for disciplinary proceeding as well as criminal proceeding. Lordship, section 50, punishment. Fifty-one, in fact, not 50 is the civil offences not triable by a court code, and 51 punishment by force code.
What is a force code?
Force code laws is defined in here lordship, three kinds of force code are there, lordship, and section 76 deals with force code. General security force code, petty offences force code, and section
Summary. Summary force.
Yes. And this is, and how it has to be constituted, that is also there, lordship. Section is 82, summary force code. And that is follows lordship, presiding officer and two other officers. Section 82,
Now,
summary,
this was passed by which court? Summary.
summary.
Where is the proceedings of the summary court? Is it here?
That is the
Where?
a pink one,
Pink flag.
no, record, yes, lordship. Record this pink flag that I have shown, lordship, that is the,
That is court of inquiry.
yes.
The force, summary force code.
Summary force code has, the court of inquiry is by the summary. Force. The presiding officer and two other officers, persons are there.
There is a specific provision as to how it is to be constituted
Lordship, the summary force code is
by the commanding officer of any unit, and
82,
he alone will constitute the court.
who shall be, he shall be, the proceeding shall be attended throughout by two other persons, who shall be officers or subordinate officer or one of either, and who shall not as such be sworn or affirmed. So there are three persons.
So where is that?
First page, lordship, three persons, presiding officer and one inspector and one sub-inspector. The pink flag, lordship, secretary, constitution of the court, lordship. It is in a descending order, that is the difficulty in record.
No, the pink flag pertains to the court of inquiry report.
Yes, report and people, constitution is also there, that's all.
No, this is only court of inquiry. You can go through and tell us. You have been given opportunities, your statements are recorded, you've admitted. You have been a habitual offender. You are found to be deserting.
Whatever I have done wrong, my lord, since because of my family problem.
Your ground is that you have already suffered punishment.
Yes, I have
But the
already,
fact,
whatever action I got, I have already undergone the.
maybe, but does it mean?
But my lord, the punishment they have given, my lord, rule 26 is a severe punishment, my lord. As per the record, we did, my lord, I was-
No, madam, this is court of inquiry composition, not summary court, summary force court.
That is, there are three, force codes, Lordship, three kinds of force code, kinds of force code.
We agree with you.
Yes, Lordship. And force code has the power, Lordship, power of a summary force code, Lordship. That is in page, section 86. And punishment part is Lordship 51.
No, but there must be a summary force court constituted. It has to be constituted.
That,
Who will constitute it? This is the court of inquiry.
the summary force code had conducted the court of inquiry.
I don't think that is the provision of the act.
Yeah, my lord, what I understand from the function, my lord, the very person who got an inquiry, he awarded punishment, he should show the.
As per
one
summary
person
force code.
You show us from the provisions of the act that court of inquiry and summary force court of inquiry can be one and the same.
Lordship, we come to pay, section 51, Lordship, punishment by force code. So three kinds of force code.
No,
Lordship, as per-
we agree that force court has the power,
Yes, Lord.
but kindly see section. I think where is the constitution 70?
76.
76. 76. 82
Summary force code.
may be held by the commanding unit, commanding officer. He alone shall constitute the court. So where are the orders? There must be some orders, notings to say that summary force court has been constituted.
In 19 court of inquiry was convened.
Hmm.
10-9K. That there is one more, there was yellow. Pale one lot.
This is show cause.
That, they are not, one order is there, 10-9 order is there. Court of inquiry was conveyed. 10/9/10 Lord.
Eleven, nine, ten, or 10/9/10. 11/9 is the statements made, recording. Proceedings took place on 13/9.
What submitted of 39.
The 1% rule has been taken. The very person which you suppose. He was
You show us any authority that this is not permitted under the act, or the spirit of the act has not been followed. No, there is, no, this is not natural justice, divorce the act. The act, this is a statute, it lays down the prescription.
But it has not been followed by the law.
You show us how, show us which provisions have not been followed.
Well, for example, constitution of the lordship does not have to tell my lord, constitution of the summary court matter, that is also not there. And the inquiry committee, inquiry has recommended for section.
You show us from the provisions of the act, what is the procedure prescribed, and how the procedure has not been complied with.
Then he has said that matter. Inquiry was,
Is he permitted to go to the records?
Actually not, but there is nothing to hide of. There is nothing to hide for this in from your lordship that lordship has already verified that is the record.
He will go through, if you permit, in your presence. If you permit, if you don't, we are not
Actually, maybe some problem may be there, but.
problem, then forget it.
whether the lordship will see matter. So far inquiry, I have not gone manifest inquiry, so nothing has been.
His case is that nothing has been served to him. How will he respond?
Lordship is not there. Because your lordship may kindly come to section 76.
Yes.
76, rule sub-rule 2.
Hmm. Three kinds of inquiry.
No. Not 76. Another argument is that as per how they can remove him from service or discharge him, lordship, that 51 punishment by force court. Here lordship, they can deal with everything lordship. Punishment is the 51.
We agree with that, but
Yes.
you have your records from the pages that you have shown us. You are saying that court of inquiry and force court are one and the same.
Lordship.
It's not evident from the records. The section doesn't say so. Section is very clear. 82, summary force court. It is to be, it may be held by the commanding officer. And he alone will constitute the court.
Your assistant commander is the presiding officer and who is their lordship? Sub-rule 2 of 82.
Two other officers.
Yes, so sub-inspector and inspector are their lordship. They may not be there, but they may be there. Here,
Is there a separate provision for a court of inquiry? You come to page 74. Sorry, section 74. 74:1, please read the section.
yes, Lord, inquiry into absence without case.
Hmm.
Where any person subject to this act has been absent from duty without due authority for a period of 30 days, a court of inquiry shall as soon as practicable be appointed
So
by
there is a provision for court of inquiry.
such authority and in such manner as may be prescribed. And such court shall on oath or affirmation administered in a prescribed manner inquire in respect of the absence of the person and the deficiency, if any, in the property of the government entrusted to his care or in any armed ammunition, equipment, instruments, clothing or accessories, and if satisfied of the fact of such absence without due authority or other sufficient cause, the court shall declare such absence and the period thereof and the said deficiency if any. And the commanding officer of the unit to which the person belongs or is attached shall make a record thereof in a prescribed manner. If the person declared absent doesn't afterwards surrender or is not apprehended, he shall for this purpose of this shall be deemed to get deserted. So first case of that is followed. He was declared deserted. Today morning I have another case of it that in that case he was declared deserted following this second lordship.
Following.
Following this provision, 74(2), one can be declared deserter also lordship. So in that case, he was declared deserter. Here, that is not there.
Some ingredients has to be there, but that's saying disaster, deserter cannot be. Ingredients has to be
But
there.
in this case, that is, he was
The
not
order
declared
totally
deserter.
silent about that.
In this case, he was not declared deserter. Dismissed from service lodge.
Equally recommended to act upon section 21. They
Yes.
came and do the.
Section 21 is also there. Section 21 A, B, F and G lots. These are absence. A is absent himself without leave. B is without sufficient cause, overstay is leave granted to him. F is lordship, when in camp or elsewhere is found beyond any limit fixed or in any place prohibited by any general.
You show us that the matter has been conducted in terms of section 82. Force court. You say the force court has the power. The force court will have to be constituted. You are referring to 51, is it?
Punishment,
Yes,
yes.
51. So 51, you say the force court has the power. Punishment by force courts. So there are three kinds of force courts. As far as you are concerned, this is a case of summary force courts. Summary force courts are to be constituted under section 82. It has to be constituted. It cannot be deemed to be in existence. Because there is a subsequent provision for dissolution of a force court. So it has to be constituted. Then the section is very clear. It's the commanding officer and he shall constitute a court. Now, whether this force court will proceed with the court of inquiry and then pass an order, or is the court of inquiry required to be held separately and the reports being presented before the force court? When we see the powers of the force court, 86. The procedure is written down under 86. There is a procedure you have to follow. Then under 94. You will have to come with some authorities, madam. Yes, learned counsel for the petition.
Already above my lord, no established procedure over to our lord.
What is the established procedure?
My lord, so far, my lord, there are no constitution of my lord. And I.
These are only now lordship, after from lordship.
I was not aware of the C record, my lord. Had it been my lord, in my custody, I would have said it the first thing.
You go through the records and tell us. Or you tell us that constitution is not specifically necessary, it is the court of inquiry. You see, the
Court of inquiry was held lordship.
court of inquiry was held,
It seems lordship. Yes,
court of inquiry was held. Punishment was imposed, as you say, by a summary force court. Summary force court. Now, for a summary force court, there must be some order constituting that court and the court entering into a proceeding and passing an appropriate order.
those are followed lordship, the statements were recorded, you.
In the court of inquiry, these are all part of the court of inquiry.
Yes, sir.
And the recommendation was punishment under 21G.
21B.
But the force of the summary court, that's imposed punishment under 51.
21,
51.
21,
21G is the recommendation of court of inquiry.
Court of inquiry.
So that the recommendations are not acceptable, there is a proceeding that will have to be established.
Lordship, may I kindly read 21G once?
Yes,
Without leave from his superior officer or without due cause, absent himself from any school or training institution when duly ordered to attend there. Because one of his offenses is also that he had left his training lordship. Him from any school or training institution when duly ordered to attend there, shall on conviction by a post court be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as is in this act mentioned. So here it is mentioned, lordship, but section 51 also says that apart from death or imprisonment from life, dismissal or removal, compulsory retirement, these are also the punishment that can be given by a post court lordship.
correct, but where is the procedure for the force court? Can a force court simply issue that order without following the procedure prescribed under the act? Or can you say that no, once a proper court of inquiry has been held, the force court or the court of inquiry and the force court are one and the same? That is what you are trying to submit. The court of inquiry and the force court
Yes.
is one and the same.
My submission is that as per the offenses, depending on the offenses, there some must be by generally post court, some petty post court and some special
Correct.
summary post court. So
Correct.
here it from the composition, it look like that it is a summary post court lordship. Although it is not mentioned that it is summary post court.
That's
But this court of inquiry and the proceedings that is have to be followed either by the court of
No,
inquiry.
these rules and these sections are not open to such wide interpretation. If rule 82 says that summary force court shall be held by so and so, rule 86 gives the powers of the summary force court, then there must be reference to those provisions to say, or you point out a provision that no, court of inquiry and summary force court in a case of this nature are one and the same.
That whether it is 100%, that I have to obtain it.
You go through the records and tell us, otherwise we do not find that summary force court was at all constituted. The fact that there has to be a court of inquiry, although not defined, but as I pointed out, I think in section 74, there is a reference of court of inquiry. So court of inquiry is not alien to these acts. So the whole purpose of court of inquiry is like a preliminary inquiry. It conducts and gives a recommendation. And if the superior authority feels that it is to be accepted, the proceeding begin.
Commanded notice there that he is agreed.
Then,
Commanded notice agreed.
no, he's agreed, but he's a part of that court of inquiry.
So assistant commandant and two other persons. Commandant is the higher authority.
Then where does the commandant hold the summary court? For the commandant to agree, he must be constituting the summary court, summary force court. Unless you say that there is a liberty not to constitute. Because, why I'm saying, because rule 21A, 21G is applicable only on conviction by a force court. If you read 21G, it says so and so will be punished on conviction by a force court. So there must be a force court established. Constituted.
Next phase of the composition of the there is one phase more that where the opinion of the court of inquiry is there, who opined that is 21 phase is there.
Correct, that is the recommendation. But merely because it is opined, you cannot impose punishment under 21G because the section itself says it shall be on conviction by a force court. So the court of inquiry findings will have to be taken note of by a force court and appropriate orders be passed.
Whether there is a necessity of again another force court is there of that I have to update.
Please do. Then or we close it, you furnish your written arguments, we close it, what is there to be heard from the records? Prima facie, it appears it was not posted. Prima facie.
One thing I again want to.
We'll give you one more date. You get it on you get it on 21st. 21st. At the request of MS B. Sharma, the matter stands deferred till 21st of August, enabling her to complete her instructions in respect of the records relevant for the inquiry of the petitioner, which is the proceedings of which are received, proceedings and the punishment imposed on which are received in the present petition. Mr. J.I. Bhavnia, current counsel for the petition, does not object to the prayer made. List on 21st of August. We give you liberty to make a mention on 24th. Bring it to the notice that this matter is listed. It is, but this will come for hearing. So 21st is a miscellaneous day. So we give you liberty to make a mention to say that this matter is fixed today for disposal. Right? 21st.
Other items, 9 and 10.
I'm appearing item number 10, recollect. On the last occasion, in item 9, Mr. Mohammed appears, he had made a submission. That the punishment which was given by the appellate court, appellate authority Having of compulsory retirement is not one of the punishment prescribed under the state rule. And therefore, these clients have been, is agreeable to any other lesser punishment as per the rule. Your lordship wanted me to take instruction whether my client would also be agreeable to such a order. I have checked. In fact, there has been an amendment in 2011 by which compulsory retirement has already been added, my lord. I'm handing over a copy of the amendment to your lordship.
Added to the rules.
To the rules, my lord. So therefore, possibly that argument will now not hold. Your lordship will see
So,
this.
Mr. Bonto, what do you say?
Well, the actually, and then around, there is, the other ground as well.
So your earlier submission will now become,
I won't press on that. The
Not-
other ground, like,
you are not pressing at all, or you are pressing in conjunction with your earlier submissions?
I was not pressing at all. I was not aware. In fact, the NRL website also does not have the amendment. I got a copy of the rules from the website.
Right, in that case, like, Mr. Mohanty finished, my lord, I will do my part on any other day, my lord.
You have finished already?
No, man.
No,
I think that
what is there to argue?
lot of grounds.
You created some mischief, you are thrown out.
Nothing, man.
Now you are pleading that you are a young boy with family, etc., etc.
Nothing, case for no evidence. That's all.
Yeah, the
Clear
strict,
to be
strict,
recorded.
strict rules of evidence are,
No, not
there's some,
required.
some allegation is there.
Not required, but the major charge matter,
Hmm.
that was not proved at all. And since the charge is not proved by the penalty of removal.
Will you not complete today?
My lord, but ideally, I would prefer on another date, but in fact, I will have the impression that we will take another 45 minutes or so. That,
We'll give you exactly 20 minutes to complete your argument.
25.
20.
your lordship may give me another date, my lord, I would prefer.
Let us first see. Yes, start.
Because it be narrating facts chronologically, so that my can take note of the dates.
List of dates you furnish us separately.
I'll furnish it. Just for the clarity, matter, just narrative.
Inquiry was on two charges.
Yeah.
Disposed of more materials over and above the scrap materials. And the materials were disposed of on an off day without prior permission.
My lord, what had happened,
Hmm.
I'll briefly narrate my lord, the story, my lord. In the year 2013, a fire incident took place in the NRL premises. That was exactly on 35/2013. So thereafter, my lord,
You are the junior officer.
I was the junior officer, my lord, I'm the.
So you should have allowed Mr. Goswami to argue, he's the senior officer. You could have taken a defense that no, he's the senior officer, he asked me to do all that, I did, I don't know. Because otherwise, I am a junior officer. I am supposed to follow the senior.
In fact, my lord, what is the crux of the issue, my lord? The NRL is trying to portray a case, my lord, that in place of scrap and damaged goods, we had allowed certain usable products, usable goods to be taken away by the bidder. That is in sum and substance, that is the main ground, my lord. And according
Which
to
was identified by that officer of the ACP.
my lord, everything was scrap. I'll come to that, my lord.
Hmm.
After the fire incident took place, my lord, there were a lot of scrap which was generated, my lord. Lordship may kindly come to page 36 for a moment, my lord, annexure 2 of the writ petition.
36.
Lordship would see this is the approval for disposal of the CDU fire damage activity. Lordship would come to the background. While finalizing our claim, the insurance company will either adjust the salvage value of damaged material, hence to get the salvage value of the declared fire damage items, finance is requested warehouse to arrange for disposal of damaged scrap items. Lordship would note damaged stroke scrap items generated due to fire accident. The scrap materials consisting of ferrous and non-ferrous metal items, including burnt cables generated due to the above fire accident, are dumped at scrapyard and kept in separate lots.
Now, I'll again read this line. The scrap materials consisting of ferrous and non-ferrous metal items, including burnt cables. So that means, apart from burnt cables, there are other scrap items which were ferrous and non-ferrous. Generated with the above fire accident were dumped at the scrapyard and kept in a separate lot. As the repairing jobs were taken up on wall footing and simultaneously housekeeping was to be maintained, including site clearance from safety point of view, scrap materials were shifted to scrapyard even in the night hour. As weighing was not done, evaluation of weight by segregating items by engaging manpower, lifting equipment, tractor trailer, weighing will incur substantial cost are proposed to auction lots namely ferrous, non-ferrous, the metals and burnt cables. My lord would then come to total quantity of the lot. Now, the first column or the fourth row, my lord, total quantity in the lot.
You are referring to page 36,
36.
total quantity.
Total quantity in the lot.
You are referring to
The fourth row, my lord.
total quantity.
Yes.
Lot one,
Lot one, ferrous and non-ferrous scrap item. Lot two, burnt cables. So it was not only burnt cables, but it was ferrous and non-ferrous items. And comment, my lords, lot number one, the next row. Number two, all fire damage material shall be offered as 2 lots, as is where is basis, my lord. So the scrap were neither weighed or they were neither identified.
what is the meaning of 2 lots?
2 lots, there were 2 lots of scrap metal. One was ferrous and non-ferrous scrap item, and the second was burnt cable.
So essentially what you are saying is the total quantity read with the comments.
Yeah.
Reveal that there were 2 lots.
2 lots,
One lot was ferrous and non-ferrous scrap item.
scrap item, the
The
other
other
was
was burnt
burnt
cables
cable,
and
they were
both were fire damage
fire damage,
items.
and they were not located in one area. It's as is where is basic number. Lordship would see comment number 2. All fire damage material shall be offered as 2 lots, as is where is basic. My lord, see.
As is where is basis.
Yes. So it was not located in one particular location. Now, my lord, come to my lord, on 15/3/2014, that date, my lord, should note, that was the date when the lifting of the scrap took place, my lord. There was this elects a party who was declared as the highest bidder, and the date of lifting was decided to be on 15/3/2014. Pursuant to lifting of the materials, what had happened, a few journalists and some ASU boys, my lord, they lodged an FIR on the same day, on 15/3/2014, claiming that the NRL authorities are giving away good usable materials in place of scrap to the bidder. And accordingly, on the same day, the trucks were seized by the police on 15/3/2014. Now, my lord, lordship would kindly come to page 37 for a moment, my lord. It's a letter dated 18/3/2014. It's a letter by the officer in charge, Numoligarh Outpost, to the GM NRL, page 37.
Page
37.
37. Yes.
With reference to the subject side, I would like to inform you that we have seen 3 number of trucks which were carrying scrap from NRL on 15/3/14. As company received from Shri Hemanta Soitia, the trucks are kept in front of NRL outpost for verifying the materials about its genuineness and taking further action. Therefore, I request you to kindly take to one officer from your end for verifying the scrap material. Now, thereafter, my lord, on 23/2014, the 3 trucks, my lord, which were seized by the police, they were inspected inside the NRL campus in the presence of the police, executive magistrate, 2 employees of APDCL, 8 persons representing the complainant. Now that inspection, my lord, would find. Inspection took place, my lord, on 23/2014. The report of inspection, my lord, will find it at page 40, my lord.
Yes,
Page 40. Now, this is the report of the inspection, and this is a very crucial part. May I kindly read it, madam? 20th March 2014, report on the inspection of the fire damage cables carried out inside the refinery area on 20th March 2014 afternoon. Well, first 2 paragraphs are relevant. The third paragraph, on 23/2014, around 3:30 PM, 3 trucks along with police, a magistrate, 2 employees of the Assam State Electricity Board, 8 persons representing the complainant entered the refinery premises. After taking the loaded weight on the refinery weight bridge, the trucks were taken to the yard where the effluent treatment plant NRL had made arrangement of train and laborers to unload the trucks. The unloading of the first and the second truck took more than 3 hours. The unloaded cables were inspected by the police, the magistrate, the representatives of the Assam State Electricity Board, complainants, and technical person from the instrumentation department of electrical department of NRL. After examination of the cable, the technical persons of NRL certified that the same were not usable in the refinery. The reasons being they were either damaged, deformed, or short of length. The complainant stated that the tender was for CDU video burnt cable. Madam, this the complainants were stating, madam. Next line, I'm reading it slowly, madam. The complainant, the persons who had lost the FIR, stated that the tender was for CDU video burnt cable, but the cables did not look burnt. That's why I was emphasizing, my lords. There were 2 lots. It was not just burnt cables. There were other scrap also which are not burned, ferrous and non-ferrous scraps.
that is what I was asking you.
Yes.
Read with this, there are 2 lots. One is ferrous, non-ferrous, one is burnt cable.
Burnt cable.
Now, where is that?
My lord, that, my lord, page 36.
36. 36.
The complainants were of the opinion that only burnt cables were thought to be.
So what is the meaning? What is the meaning of page 36, serial number 2? All fire damaged material shall be offered as 2 lots.
2 lots. 2 lots, the lots are
As is various basis.
lot 1 and lot 2.
Correct. So lot 1, if you say
Yes.
is not fire damage.
Yes.
Then you have to give some meaning to the comment at serial number 2.
Yes, that I'll come. Lordship has asked a very pertinent question. That Lordship would, I'll show you from the evidence. What the technical person say, my lord, in the evidence, that after the fire incident took place, my lord, I'll explain, my lord. After the fire incident took place, there were number of scraps generated. The first type of scraps were fire burnt cables. Because of the fire, the cables were burnt. Those became scrap. And the second, my lord, ferrous and non-ferrous, what had happened, my lord, to replace those burnt cables, new cables were installed. And while installing the new cables, they were cut pieces of those cables and other things which were unusable, things which were generated, my lord. That was also included in the tender. Evidence would show, my lord. So there were 2 lots, not just burnt cables, there were other scraps also. Now again coming to page 41. The complainant stated that the tender was for CDU video burnt cable, but the cables did not look burnt. The technical persons of NRL stated that they are not aware of the tender, but reiterated that the cables of this first truck, which should be first 2 matters, were scrapped. The views of the employees of the Assam State Electricity Board were not known, but it was heard that they were unable to give comment on the cables since they are not.
If it is first truck, it is first truck. How do you say it is first truck?
Because say why.
Anyway.
Lordship will again.
Anyway, carry on,
Read paragraph 4 from the start.
carry on.
But it stated that they were unable to give any comment on the cable since they had not brought any instrument with them. Police took statements from all concerned. Weight of the unloaded truck was taken. In fact, the first two truck, there is no dispute. Matter. Unloading of the third truck. This is where the dispute arises.
Hmm.
Unloading of
Where is the tender? Let us see the tender first.
the tender is not on record.
Tender is not on record.
But the approval for the tender is there, madam, which my lordship produced that page
Page number,
36. That is the approval for the
that is the approval.
approval.
Tender is available, madam. All right,
Madam, paragraph 5, page 41.
yes.
Unloading of the third truck started in a similar fashion. After unloading almost the whole truck, at the bottom, there were two coils of cables of quite large dimension. On seeing these cables, the complainants insisted that these were new cables. Further, they insisted that these cables should not be unloaded as the crane may cause some damage to the cables. And taking this excuse, NRL technical person will declare the cables as not acceptable. These two coils were inspected on the truck itself by the police, the magistrate, the technical person. The magistrate ordered for sealing these cables for further testing.
Now, what is the finding of the NRL technical people in respect of
NRL,
this?
madam, because NRL is, they were, madam, problem was, madam, there was a lot of pressure from the ASU and those journalists, madam. That's why, but my lord, the technical people, ASB was also present, my lord. Lordship would directly
They
come.
said that we cannot decide some instrument is not there.
No, they're there, my lord. The magistrate ordered for sealing of these cables for further testing.
Hmm.
Now, my lord, will directly come to the report filed by the APPCL, my lord, page 44.
Hmm. Yes,
Lordship would first see, this is the subdivisional engineer, Pomargaon Electrical Subdivisional APPCL to the Assistant General Manager. Before I read, my lord, Lordship would see at the bottom, it has been marked to the magistrate, that is the circle officer, the GM Commercial NRL, the OC of the Numaligarh office.
this is in respect of those different types of cut pieces.
No, my lord, kindly read the
Really,
subject first, my lord.
really.
Verification of electrical materials cables loaded. Vehicle number as follows, 3 trucks, 1, 2, and 3. There are 3 trucks, madam, 1, 2, and 3. I have the honor to inform you that as per your instruction, the undersigned visited Numaligarh refinery to inspect the materials on 23/14. That's the day of the inspection. And after unloading of the materials which were loaded in the above mentioned truck in the store yard of NRL in presence of circle officer, police staff, Numaligarh outpost, so and so. In that case, it was found different types of assorted cut sizes, cut pieces of LT and HT cable, which are not in serviceable condition and are also not sweet for any purpose. So after my inspection, I consider all materials as condemned, unserviceable cables and scrap only. This is for favor of the kind information and necessary.
This is not the finding of the NRL authorities.
This is not the finding. That's my lord.
So what has happened to those
Yes.
2 rolls of cables?
There is no finding of the NRL. What they try to do, my lord, while proceeding with the inquiry, that charge that serviceable cable was given as scrap, my lord, that was never proved. So to prove that, they come up with some photographs which were initially not at all part of the evidence. My lord. Now, my lord, you see this APDCL. It's a technical matter, it's a report by technical authority. my lord.
Quite right, but what is not evident from the judicial report is that the details of the goods which are examined.
My lord,
It has to be marked exhibit 1, 2, 3, 4 or something like that.
My lord, it's scrap. It's consisting of 3 trucks, my lord, that could not have been.
You now have to correlate with the finding of
Yes,
the,
it are correlated.
with the NRL
But
officer
the fact remains,
who has given the
that all-
report.
the eyewitness account of the APDCL,
Hmm.
it says that all the materials in the trucks were scrap. So the NIL authority
The
cannot.
question is
discard-
not there. The question is whether, while examining, whether these 2 rolls were also made available to the ACB for examination.
That's what I'm trying to. with all due respect.
You are trying to impute that these two roads were part of that truck and therefore ACB was given. Let us go to the ACB again, 44.
My lord, to correlate, lordship.
1 minute. Let us read again.
The report for his lordship,
No, the page 44.
case for. ACB was personally present there. They have inspected all these three trucks. You don't have to say in so many words that these two coils and other things were. Everything in the three trucks were, and the fact that the two coils were there in the three trucks would be evident from the report. The inspection report.
And we come to page 41, serial number 6.
Yes. Page 41, serial number 6.
41, serial 6.
These two coils were inspected on the truck itself by the police, the magistrate, the complainant, the technical persons of NRS. The magistrate ordered for sealing these cables for further testing.
Then,
Can I read further?
so these cables were sealed,
Not part of this.
not the sealing took place only of these rolls of cables by the magistrate. Whether this was examined by the AAC.
This was, everything in the truck was examined.
No. That will not give a finding that it was sealed, mind you.
Well-
He could not have broken the seal and examined it without the authority of the magistrate.
That's not the case. Madam.
Uh,
Inspection took place on 24. This report which I'm referring at page 44,
Hmm.
this report is not afterward. This is the
Before,
report on that day itself, when the ACB was present. Sealing was done thereafter, madam, or whatever.
all right.
ACB was already there, madam. When, because the inspection took place in the presence of the magistrate, the ACB.
So therefore, in the report, the AACB did not examine it.
ACB examined, madam.
In the report,
Report is, madam, on that day itself. I have the honor to inform you that the undersigned visited the Numaligarh refinery to inspect the materials.
kindly come to page 41.
Yes.
The beginning of that paragraph towards the end.
Yes.
The views of the employees of AACB
Yes.
were brought as a neutral inspection agency. Can you read?
Neutral, inspection agency were not known at that point. But it was heard that they were unable to give comment on the cable since they had not brought any instruments with them. Now, madam, that is the burden of the NRL authority. We have heard, but there is a document in front of my lord, madam, which says that after inspection,
This examination by AACB took place when?
that's the itself, madam.
No,
But the report is dated
it is submitted on 22/3. Signed by 22/3.
Signed off by
Inspection is mentioned in that.
it's mentioned 23/14.
Sorry.
The date of
The second
inspection is mentioned as on 23/14.
Where is that?
Second line.
Second language.
Oh.
I have the honor to inform you that as per your instruction, undersigned visited Numaligarh refinery to inspect the material on 23/14. So therefore it is immaterial. After that, it was sealed out, whatever was done. After inspection,
Whether these two tables.
No, it's not immaterial because it will have to be now correlated.
yes,
Either this report of AACB is not correct or the report of the Numaligarh recording that AACB could not give a comment.
that is their surmises. madam. They say we've heard.
Number one. Number two, assuming that on the date of seizure, let us say immediately they examined, they could not give, subsequently they gave a report, having examined on the same day. Neither the report nor the finding of the AACB reveals whether these sealed cables were examined.
So my lord, I'll read it again.
But just for clarification, the subject your lordship, in fact, three truck numbers have been mentioned.
Correct, but it was sealed. It was sealed by the magistrate.
One,
The
the
seal-
third truck.
It was sealed later,
Seen after the
after
inspection.
the inspection, it was sealed.
Let me
And
clarify.
this is the report on the date of the inspection.
Therefore, I am saying that it has to be correlated.
Yes, in fact, let NRL come up with any report which says, my lord, then I won't argue any further. my lord.
All right,
Let NRL come up with-
your time is up.
my lord, I'll just finish.
Your time is up already. It's one past.
Lordship, I had just
Let
one
NRL come up
certified
with a report
this, I read this annexure 2 lordship regarding the approval for disposal of the scrap material. Lordship will see both the petitioners
were present when this lot was approved for auction launching. They knew exactly where the scrap was, there was no scrap, where there was good cables. Both of them have signed lots.
Learned friend will get a
But
chance.
where is the finding that these are good cables?
No finding. In fact, in their affidavit, they have stated that they are not usable cables, they are scrap. I'll show that, my lord, after lunch.
Anything more?
You come. I need it.
I have some difficulty with the signal, so let him finish it first, by you will be.
Let us.
Another date.
10 minutes.
And in instruction, now we need to find an additional affidavit on this matter. So, madam, I am just in a short date. And then.
At the request of Mr. Arnold, yes, Mr. Foucault, any objection?
Within 2014 matter and very important.
What is the instruction you want to bring on record?
My lord, two things, my lord. That redaction list, my lord. I have, and few instructions, my lord. Means, my lord, he has filed another additional affidavit. In 2015, we have some objection there, my lord.
He is challenging the appointment of some person,
Person in a
promotion.
promotion in an additional affidavit when he was not a service. He has retired in 2013 and he is challenging, my lord, the promotion of the his colleagues, my lord, in 2015 when he is not in service. That also, my lord,
Because if you file an affidavit now, we permit you, then he will be entitled to file reply if required.
I have no, I have no objection with that.
No, you may not have objection, but the fact is the matter is pending since 2014.
My lord, but I understand, my lord. But my lord, the thing is that whether that affidavit is maintainable, my lord, was those colleagues are not made a party.
We'll see.
And these are the things, my lord. You legal,
What is that thing that you want to bring on record?
my lord, the gradation list of when you was in service. Then
All right, you, how much time do you require?
I need short date, so since I have the documents with me, my lord. My lord, it will permanently just after Independence Day, my lord.
21st,
My lord.
21st. At the request of Mr. Arnold, matter stands adjourned to 21st of August, enabling him to file the additional affidavit as it is submitted that instructions of the department have been received. Mr. KK Foucault submits and can be made to dispose of the petition on the next date fixed. Accordingly, this is the matter again on 21st of August. Is it partnered? If it is partnered, it is partnered. If it is not, it is not.
It is not yet part my lord.
If it is not partnered, then we are not looking at partnered. It will come. Isn't it? Yes. See, what is the problem is that we are going on a piecemeal hearing.
Yeah.
So we need to finish off this matter on a particular day. Where is the other counsel available to appear and argue the matter? Then otherwise it makes no sense. I hear you today, again I hear you the petition on some other day, respondents on some other day. The issue is very short. That whether these items were at all which were sought to be disposed of were usable cables or not. Is there any finding to that? And whether the subsequent evidence sought to be brought in by the NRL can be admitted. That is the only issue. So then, what more is to be required? It's only a question of examining the laws and the position in law, read with the rules. There are no disputes as such on facts other than the evidence part.
No, there are all total 5 charges.
Hmm?
In the memorandum of charge, there are all total 5 charges. The most crucial charge is the charge number 4, who are the petitioner in the instant case, which says, my lord, I allowed lifting of 2 cables which had a book value of 16 lakh. Now, if I can prove, my lord, that 2 coils, even if it was there, it was unusable and it was scrap, then the other charges, the other misconduct, my lord, it would not even qualify as misconduct.
Let us hear it on 31st and finish it off. You continue on 31st and whatever, because we are not closing the hearing today.
Yeah.
So therefore, there is no point again hearing you and again deferring the matter.
I just argue on those 2 points.
Whatever you want to argue, we are not closing it. You argue. Please inform the other council that we are fixing on 31st. And we would like to please inform your
Yes, Lordship.
cleaning
Mr.
council.
Nayak.
Because and they keep the records available so that we can finish it off.
Records are with them.
Right. Since all the councils are not available today, this court proposes to take up the matter on another date, on which date an attempt will be made to complete the hearing of all the learned councils appearing for the respective parties. Therefore, this is the matter on 31st August.
Lordship, can we have it on 29th? Tuesday.
All right, 29th August. 29th August. Please inform Mr. Goswami. on that.
Community list further items 21 to 34.
You are supposed to submit on that issue.
Yes.
So
Approximately take up 2677.
2677. WBC.
This scheme to date 17. Why was your office with regard to eligibility to
17.
70?
70.
If it is the scheme, part of the thing, second,
Yes.
I have to go your object section to paragraph, close 4.1.
4 point?
One,
Yes.
page 71.
Yes.
Eligible, it means which was eligible before first day of July 2017. You avail benefit of having exemption or exemption by way of fund from payment of central excise duty under notification of the case may be issued in this regard listed in para 2 above and was availing the exemption immediately prior to 2017.
This is what? This is the
Eligibility, the name of the eligibility. As defined. Last edition, we are on close B. And we also pointed out that in this clause, the applicable it means that it is eligible. If I discuss the matter with the close 4.1. Because here, let's say, admittedly, the listeners, they were found to be below the threshold limit and some were not registered, because they were not able to register at the relevant time. Now, as per this notification, those units which are not registered, prior to 1/7/2021,
if you read 4.1,
yes,
it talks about eligibility.
yes, also.
So whether you are eligible, it doesn't talk about availing benefits. It says eligible to avail benefits.
Yes, also, consequently to see. Payment of central excise duty under notification as a case, but the first line. Payment which were eligible before 1st July of 2017. To avail the benefit of revenue exemption or exemption by way of refund from payment of central excise duty under notification as the case may be issued in this regard. Listed in para 2. This is important.
Para 2 of what?
Para 2 of the history. It start from page 70.
Hmm.
70. Plus, the external schemes which were in operation on 18/7/2017 were this program. 4.4, 2.1 for Jammu Kashmir, 2.2 for Himachal Pradesh, and 2.3 for the Northeast state. Here also it states that the notification number 20/2007 dated 25/4/2007 is emitted from time to time. Now what's it here includes 4.1B, which mention about the notification with respect to Jammu Kashmir and Himachal Pradesh. They missed out the notification with respect to notification number 20/2007.
Then you read the last line, eligibility of the unit,
Notification.
para 4.1 last line.
Yes, also, the eligibility of the units shall be on the basis of application filed for budgetary support under the system with reference to A. Central excise registration number for the devices of the eligible manufacturing units and it existed prior to certification of GST. And B, the GST registration for the premises as place of business where manufacturing activity under notification 49/2003. This is with regard to Himachal Pradesh.
And the unit was,
And 50/2007. There is being carried out censorship. And the units not registered under the central excise.
this is not applicable for Northeast.
Nothing.
You are saying this is not applicable for Northeast.
Yes, also, because that notification is not mentioned. Only notification of Himachal Pradesh and Jammu Kashmir is mentioned. And then there is subsequently some clarification in form of circular.
59. Okay.
This is the clarification. And subsequently, three notifications circular were issued clarifying who are eligible to under. In my comments, this is not an extension of the scheme. It's only a clarificatory note. In form of circular. So the basic logic for my comments is and it is provided for notice of you. And those units, the petition units are not eligible to get anything under this scheme.
Hmm. Yes. Hmm? Oh,
His cousin expired.
Huh?
His cousin expired.
oh. No, we were just asking him for a clarification, that's all. So then, when will he be available? We need to close the hearing. We have to close the hearing, he's already argued. When would he be available?
Yes, Your Lordship, immediately.
24. Twenty-one is a Monday. All right, then let us take it on 29th. 29 August. 29th. So you're saying that this clause 4.1B is not applicable to the petitioners.
It is applicable to this matter.
How you say it is applicable to Himachal and Uttarakhand?
Check for clause B. Clause B has not stated. After 172, it will get a full stop.
Hmm.
The first 4 lines, which determines the eligibility of the individual which are entitled to get benefit under this scheme. Clause A and B makes the individual eligible
Eligible for what?
for getting benefit under this scheme.
That's right, that is the issue here.
But here, Lordship, they were, it is admitted that the petitioners were not registered under the central cycle. Due to, there are 2 reasons. One was they either they were exempted or they were below the threshold limit. So they were not registered. Under the central cycle. The condition here, Lordship, the individual must be registered. Again. Second, there is after the volume of the GST, every unit needs to be registered. So there is no dispute with that. Subsequent circular also. Although my senior is indicated that by swing circular, the basic scheme, they cannot be expanded. Contrary to my submission is that this is not a, this is only a clarification. Whereas basic scheme, it is clarifying itself.
It is submitted by Mr. P.K. Bora that the London City Council. Dr. Singh Saraf is not available in court because of personal emergency. He had to leave court, therefore, please that matter be deferred, taken up on another date. Mr. Both the councils present for the parties agree on a date, which is 29th. He did 29th. 29th of August. Or what really.
Item number 12.
Item 12. Yes.
On account of politics, I will go to the record when I'm good at case. They don't think it's another day. If you are not they can start thinking like.
Thursday. Coming Thursday. Coming Thursday.
On
Thursday. 10.
70. May 70 to 20.
Then let it be on
24. 24 months.
I find it strange, these are 2016 matters, you are deferring matters. Why?
For the first time I'm displaying.
We are ready to take up the matter on coming Thursday, you know. Why are you can't argue the matter on Thursday?
Actually, I have not still recovered my.
It is submitted by the learned counsel for the petitioner that is disposed and not in proper physical condition to address the court, therefore he plays for 2 weeks further time. Matter be listed again on 12th of September.
Fine.
Learned counsel, Mr. Franco appears for the respondents.
All right.
Item number 13.
Parmar,
Now, yes. Now, here the only question was that, madam, whether.
appears to be covered.
Yes. I will try to make out a case from my side. Parmar motion says the question whether unauthorized absence from duty amounts to failure or devotion to the duty or behavior unbecoming of a driver servant cannot be decided without deciding the question whether the absence is willful or because of competing circumstances. Now, my learned friend was referring to the departmental investigation report. It starts at page 37. And he was more particularly referring to paragraph 8 at page 39. Findings of the investigation. Though, worship, when it had earlier come up before the single judge transfer only of the medical certificate. Anyway, he has made some changes and division bench has remarked it.
1 minute, there is a division bench judgment of this court.
Yes.
You are relying on this.
Formal case, madam.
No, Parmar, yes, but you are also relying on the division bench. And then I am bound by this
Yes.
because I am a,
Yes. No, division.
I can't take a contra view unless.
Court cannot say it could have been concluded there itself. It has come back. But since it has come back, I take the opportunity to address your question on paragraph 8
Of
of his report. It starts at page 37. Because his submission before the division bench was the procedure was not followed. Procedure what? Procedure he relies upon Parmar. Now let us see paragraph 8. That was primarily his argument on that. Now we, as per Parmar, we have to see whether the absence is willful or due to compelling circumstances. If it is due to compelling circumstances, I have got notice. But if it is willful, I have notice.
therefore,
The charge motion I have read out, because
Parmar says merely because it is unauthorized absence. It will not amount to. Without evidence, it will not amount to willful.
that is what I just said, but I will just see that once again. The question whether unauthorized absence for duty amounts to failure of devotion to the duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful
You are reading from
from Parmar judgment of.
paragraph number.
Motion in mind, it is paragraph 16.
There are 18 members.
17, 18 and 19, he is reading below 18. In my different.
You are reading from?
The question whether unauthorized absence.
The opening lines are question.
The question whether unauthorized absence. Understood, question.
Para 16 doesn't begin with that sentence.
In the case of. What should we take from paragraph? 16?
Yes.
Another statement. Because here we might.
You are reading from middle of 16, not the opening lines.
In fact, on my.
It is the opening line.
Second line is. My channel is. The question whether. Logic is referring to SSC.
Yes, all right. The question, yes.
The question whether. Unauthorized absence from duty amounts to failure. Of devotion to duty or behavior. Unbecoming of a government servant. Cannot be decided without deciding the question whether. Absence is willful or because of company circumstances. Now. If the absence is a result of compelling circumstances. Under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like witness service. Now, the catch here, Lordship, is if he is absent for compelling circumstances, it is not willful. And if otherwise, it may be willful. Compelling circumstances, okay. Now let us see page 39 of the writ petition. Page 39 of the writ petition.
Yes.
Let us read the whole paragraph. Finding of investigation. From the departmental investigation, it is learned that constables were absconded. Lordship remarked the word absconded. From line around 1700 hours and 5 battalion force and other companies were informed on the basis of witness number 3 and evidence number 1. On the basis of evidence number 2, 3 and 4 and witness number 3, an FIR was lodged against the constable Comfort Bezbulwa on 15/10/2010. On 20/10/2010, a complaint was made to the Chief Judicial Magistrate and Commandant 5 Battalion Force against the Constable Comfort Bezbulwa and admitting the claim. The Commandant 5 Battalion Force issued a warrant of arrest in connection with case number so and so dated 28/10/2010. But the police failed to produce Constable Comfort Bezbulwa before CGM commanded. On the basis of evidence number 5, 6, 7 and witness number 3, steps were initiated to stop the payment of the salary and allowances to Constable Comfort Bezbulwa. On the basis of evidence number 8, Constable Comfort Bezbulwa appeared before the investigating officer. But on 19/7/2011, he again absconded before completion of the investigation.
He did not appear.
He appeared.
No, he appeared, then he did not appear.
He appeared for a short moment and he again.
No, he appeared and then he did not appear. Whether the non-appearance can be termed to be absconding.
He was an absconder, declared absconder prior to that. He was a declared absconder prior to that.
No. That is the whole case. He was declared absconder because he was not available. It is his case that I did not abscond, but because of compelling reasons, I could not
That
appear.
is what I am coming to. The next one.
Ah.
On the basis of witness number 1, 2, and 3, Constable Compass Velcro was found to be obedient to his duties. But no information could be found as to why he had absconded.
Hmm.
As per version of the accused, he absconded and remained absconded due to be owing to his mental illness or mental stress or illness. He took treatment from a general doctor, but he has no proof as to whether he suffered from such disease or has been suffering